Hello and welcome to Quadcast, Quadrant Chamber's weekly discussion forum looking at news, legal developments and hot topics in the world of commercial litigation. The format is very simple. Drink, talk, chat. Drink, we want you to join us for a drink. It's 5 o'clock. It's about the right time. I am drinking a delicious homemade by my wife ginger beer. Talk, we're going to talk about a legal topic. This week we're talking about anti-suit injunctions. And chat, we want you to join in. You can join in by sending us questions by email, quadcast@quadrantchambers.com, or you can join in on the YouTube chat function. And there might be a vote in the course of today's programme. And to do that, you'll have to go to www.quadcast.vote, and we'll show that URL on the screen when the time comes. And hosting Quadcast with me today, it's the team, Poonam Mawani, Joseph Sullivan and Claudia Wilmot-Smith. Hi guys. Poonam, what's your news? You kick us off.
Well, you guys all know, because I don't exactly hide my lights under a bushel, but it was my birthday yesterday. And it was the most wonderful day. All I'll say is there are some upsides to COVID, which were that I undoubtedly got more cards through the post, more deliveries of presents, and more gifts than in any previous year. So I'm a really happy girl. Joe, how's your week been?
Well, I've mainly been thinking about your birthday, Poonam. That's been my main focus. But no, apart from that, enjoying the good weather, or pretty much chain eating barbecues. Don't seem to be getting any better at that, but we'll see. Claudia, how about you?
Also enjoying the good weather, enjoying the fact that we're now allowed outside and can meet people from outside our households. So I had my first social interaction for about, 10 weeks or something. When I met my brother, I ran to Regent's Park and he cycled, and we sat on other ends of a bench and ate burgers, and it was just amazing. And yeah, the weather has been great. So it's nice to be allowed outside more often. How about you, Paul?
Well, I have been following the Lord Sumption lockdown foray, as you know. Joe started this with the Elon Musk piece a few weeks ago, but then in the Sunday Times I see Melanie Phillips writing an opinion piece: lockdown libertarians take road to tyranny. Lord Sumption's demand for freedom of choice recalls the supercilious sex of the Middle Ages. It's a pretty robust piece. She ends up: the free spirits were burnt at the stake, while the dazzling Lord Sumption will hopefully enjoy many more years to entertain us all in the tradition of the great British eccentrics. It may be as well to conclude that the preservation of life, standards of common decency and civilised values depends on lesser mortals. I think it's a sort of a watch this space situation, because I don't see Lord Sumption taking that lying down. This week, we are looking at anti-suit injunctions, and Poonam, you're going to introduce the topic, aren't you, and tell us a little bit about it to start with?
Yeah, okay, so there are two general ways, roughly, that you get an anti-suit injunction: by showing you have an exclusive jurisdiction clause, or on the grounds of vexation and oppression. And Joe's going to talk about the latter in a bit. But first of all, what you need to show for the first head is that you've got an exclusive English jurisdiction clause or arbitration. And the courts have been helpful to the extent that they've said you don't need in the clause to have the word exclusive or only. That would be a unnecessary surrender to formalism. But then in a really unhelpful guidance, they've said what you're looking for is a transitive obligation, not an intransitive obligation. And I don't know about you guys, but I don't even know what those words mean, and I still don't really understand what they mean. But what you're looking for is that there is a positive agreement and promise that you will sue only in one place, but an intransitive promise or agreement that you're okay to submit to just one place. That's not enough. It's got to be positive that you're going to just go to the one place. The other thing to know about exclusive jurisdiction clauses, because it's useful, as we'll discuss later, is it has a positive and a negative connotation. It's positive in that you have a positive promise that you're only going to sue in that one place. But you also have a negative right, which is you have a right not to be sued anywhere else. And that's important, as we'll find out later. So let's assume you've got an exclusive jurisdiction clause. You go to the court for an anti-suit, or ASI as I call them. Claudia, you won't necessarily get it. Sometimes the court refuses. Do you want to tell us about that?
You'll mostly get it. So if there is an exclusive jurisdiction clause, you'll get an anti-suit unless there is a good reason not to do so. And that test comes from the angelic grace. What is a good reason? Well, if you're looking at the authorities, I think it's worth considering the date, actually, when the decision was made. I don't know how many of you have read Nancy Mitford novels. She writes Interval. She's very English. Her protagonists loathe abroad. There's this Uncle Matthew character. Abroad is bloody and foreigners are fiends. And the English...
One of her sisters was okay with people from abroad, right?
One of her sisters was fairly okay with particular brand of foreigners. Yes.
A particular kind, yeah.
But the right sort of English person loathes abroad. And there is this undercurrent in some of the older cases that actually there's no good reason to allow proceedings to continue abroad. But I think that's slightly started to change, right? So now you will still get anti-suits. I mean, they're issued all the time, but the courts are starting to recognize that there may be good reasons not to issue one. And an important good reason is delay. In 2016, Mr. Justice Walker considered a carrier who had been sued by a bank in China. The bank held a bill of lading, they sued in China, and the carrier disputed jurisdiction again in China. Then, 8 months later, they came to the English court and said, actually, anti-suit please because of this arbitration agreement. Mr. Justice Walker said, you acted too late. This delay is a good reason not to give you an injunction because in that time, this jurisdiction dispute has gone to the Chinese courts, their time and their resources have been used. And so for comity reasons, that delay is a good reason to refuse an injunction. The delay period is between the issue abroad and your application in England. And we are here talking about where it gives rise to these comity issues, not where it means that the foreign claimant would be met with a time bar defence. That gives rise to slightly different issues, what we'll talk about. But when you're thinking about this delay, it's not like a knockout blow, right? So in a recent case, Daichi and Chubb, there was a quadrant versus quadrant affair where they said, delay, comity, good reason, we shouldn't be anti-suited. That actually didn't work there because they said these comity concerns weren't engaged. So you have to look at what's happened abroad before deciding. But Paul, I think you've managed to persuade the court that there are other good reasons. So if you haven't washed your hands for 2 minutes, you can not get an injunction, right?
Well, I can't claim credit for that. But I think before we go any further, we've got an example, haven't we, Poonam? This is your example.
Yeah, sorry, messed up earlier, guys. Forgot to get the light up. Sorry, everybody. Sorry, the heat's got to me. I'm going to pose a problem to the panel later on, but we'd like all of you viewers to please also vote. If I could have the slide up. Imagine this is the jurisdiction clause in a contract. All disputes arising out of a relation shall be subject to English law and the jurisdiction of the English High Court. Then it goes on. If, notwithstanding the above, either party commences proceedings in a jurisdiction other than England, then it's agreed such proceedings shall be court proceedings and not arbitration proceedings. So, guys, we'd like you to vote, please, as Paul said on www.quadcast.vote. Say yes if you think it is an exclusive English jurisdiction clause. No if you think it's not. And we'll give you the results towards the end of the programme. Sorry for the mess up, Paul. Over to you about washing hands.
No, not at all. So, yes, do vote. We want as many people to vote as possible. We need a reliable result on this, because it's going to be controversial, I guarantee it. Yeah, so clean hands. I always thought after Tinsley and Minigan that clean hands as a doctrine was pretty much dead, given the very restrictive approach to illegality and the statement that clean hands was basically the same doctrine with an equitable hat on. But RBS and Highland, it opens up, I think, the doctrine again. So just to recap, RBS and Highland, RBS suing Highland on some collateralized debt obligations, securitized debts that have been packaged up and sold on the market. And they won liability, won summary judgment on liability, and then they went to a quantum trial. But after that, Highland discovered that RBS had suppressed documents, and they sued in Texas for damages for the fraud they said that RBS had conducted in the context of the English proceedings. RBS did get an anti-suit injunction to stop it, but only to stay the Texan proceedings until there could be a trial. And then Mr. Justice Burton at the trial, so this was the third stage of the proceedings, found yes, there had been dishonest suppression of material, and that misconduct opened the way to apply the clean hands doctrine and refuse the anti-suit, allowing then Highland to continue their action in Texas. So my take on that is clean hands are back, possibly in fashion, can run it on an anti-suit injunction and any other injunction. Who's next? Joe.
Yeah, so as Poonam said at the outset, probably the principal way that you get an anti-suit is by showing infringement. Oh my gosh.
Okay, I hate you guys.
Stop.
For God's sake.
We did this.
A viewer here. Okay, I'm right. Very rare. Thank you, boys. You're not singing. I'm going to blow the candles. Is this? For God's sake, ready? Oh God!
Happy birthday!
Happy birthday, Poonam!
Oh my God! I just burnt my hair.
Podcast birthday.
All right, carry on, people, while I sort myself out. Joe. Thank you.
Yeah,
sorry. Now that I've calmed down, that was all very sweet.
We just so that, look, if you're watching this, we didn't tell Poonam, but we arranged for a courier to take a birthday cake to her home because we love you, Poonam. So we wanted to wish you happy birthday properly, live on air.
Birthday will never end, Poonam.
Thank you very much indeed.
The principal way that, ordinarily you get these injunctions is by breach of a legal right, and typically an exclusive jurisdiction clause. Another way is by showing that the foreign proceedings are vexatious or oppressive. They're not the only two ways that the authorities stress. It is a more broad based jurisdiction, but typically it'll be one or the other. Now, vexatious or oppressive as a term has not been further defined by the courts. And in fact, they've expressly declined to do that, of course, of appeal in Deutsche Bank and Highland Crusader. And you'll always, or pretty much always, need England to be the most appropriate forum for the dispute. It's not enough just to show parallel proceedings. You do need something more. And when you look at the cases, it's usually either England is just so blindingly obviously the natural forum that there's something odd about suing somewhere else, or where the foreign proceedings have been brought really late on in the course of English proceedings, or where there's just something about the nature of or the way in which the foreign proceedings have been brought that takes it out of the norm and makes those proceedings vexatious or oppressive. And it's here really that comity features particularly heavily. Can
you give us an example? I mean, these are all words. Give us an example of where an anti-suit's been granted on the grounds of vexation and oppression.
Yeah, well, I mean, there was a case last week or maybe the week before called SAS Institute and World Programming. And briefly in that case, there'd been English proceedings which had failed, then proceedings in California on pretty much the same thing which had succeeded. The claimant in California applied to enforce that in England. Enforcement was refused. And then they brought a claim in California to enforce the Californian judgment by assignment of debts in England and assignment of bank accounts in England. So effectively steps that required to be taken in England. And an anti-suit injunction was granted by the English court in connection with those proceedings, which the English court said were, and perhaps that's unsurprising, oppressive and vexatious in the circumstances. I think we're going to now look at some specific...
Well, can I just ask, do you have to have proceedings in the UK, or can you run this argument even if there aren't extant proceedings in the UK?
No, you don't have to have proceedings ongoing. I mean, it helps, but no, it's not a prerequisite for obtaining an anti-suit injunction that there are ongoing proceedings in England. Claudia, I think you're going to look at a specific area on this.
Yeah, so you've talked about areas where there's a legal right not to be sued. Usually that's obviously based on this contract, but there are cases where someone applies for an anti-suit injunction because he has an exclusive jurisdiction clause or there's an arbitration agreement, but that agreement is not with the foreign claimant. And that can be because of an assignment or because of the effect of foreign law. So in the first situation, Joe, imagine you load all of your worldly goods onto Poonam's ship, and she issues you a bill of lading with a nice English law and jurisdiction clause, exclusive jurisdiction clause, because the obligation is intransitive. Right, I've got the anyway. Poonam then proceeds to breach all of her obligations and loses all of your stuff. because you don't have any stuff left, you don't really have the means to sue her in England. But what you do have is a policy of insurance with me, your Brazilian insurer. And according to Brazilian law, which is the law of our insurance contract, I can bring a subrogated claim against Poonam in my own name, right? So I sue Poonam in Brazil. I am not party to a contract with Poonam. I have just got the benefit of your rights, Joe. And Poonam says, hang on a minute, though. This bill of lading has an exclusive English jurisdiction clause. She applies for an anti-suit. To which I say, aha, but everyone knows that under English law, you can assign the benefit, but not the burden. So I have the benefit of Joe's causes of action against you, Poonam, but I don't have the burden to sue you only in England. And that case was called the J. Bowler, and the Court of Appeal considered that argument, which insurers made, and said, yeah, actually, that is kind of right.
Isn't that just though explicable, not as a sort of benefit burden analysis, but explicable in the sense that the exclusive jurisdiction clause delimits the positive benefit that you get? And so all that you're doing is saying that the benefit that goes across on the subrogated rights is subject to the same limitations.
But they said it's not subject to the contractual obligation not to sue. They said it's subject to an equitable obligation, right? So the way that, yes, in a sense, that was the result they wanted to achieve. But the way they did it, they say if you take an assignment of an English law right, it's subject to equities. And what that means here is subject to the equitable obligation not to sue other than in accordance with their contract. Because, so the benefit burden analysis you talk about, the burden is an equitable one, not a legal one, which was a distinction that some people thought we left behind. It seems we haven't in the anti-suit context. If Poonam, you want to enforce your equitable right, how do you do it? You get an injunction, because that's an equitable remedy. So the court said, yeah, you get an anti-suit injunction. There, it was an assignment, but it might not arise in quite such a clear context. It may be that the foreign litigant isn't professing to sue to enforce English contractual rights. So, Joe, you put your goods on Poonam's ship. She's breached all of her obligations and lost your stuff. You're keen to sue, but she's a woman of straw. She has but a birthday cake to her name. So what do you do? Well, she has got insurance. Paul is her English P&I club, and he has provided cover, subject to English law and jurisdiction. So you want to sue Paul? You can't, you don't have a contract with him, says English law. But you're Turkish, and so you know that Turkish law says you can sue Paul in Turkey because it confers upon the victim a direct right of action against the insurer. And this isn't just a quirk of Turkish law. There have been applications to resist similar proceedings in Spain and in Finland and stuff. And so Joe's answer is, I'm not seeking to enforce an English contractual right, so I'm not subject to this duty that you're talking of. Well, the court says you have to take a broad look, actually, at what you're doing abroad. And if taking this broad look, the right you're seeking to enforce is essentially contractual, then we can put on our English law glasses and use our English law rules. And in that case, they said, because your right under the Turkish statute meant that you could only claim for an insured peril, it had to be subject to cover limits, you had to bring it within the contractual time limit. They said, actually, it is an essential contractual right. So you are subject to this equitable burden, which is this English law rule. So don't get bogged down in how the claim is characterized, the name of it. You look at what it is. If it's essentially contractual, you get an injunction. But these are anti-suits. Joe, I think you're going to talk about anti-arbitration injunctions.
Yeah, well, yeah, anti-arbitration and anti-suit injunctions in the context of arbitration. I'm looking at a couple of points. The first is about restraints of an English arbitration. And here I'm talking about a case I did last year, called Minister of Finance and International Petroleum. That was a case arising out of the 1MDB scandal, where we were acting for the Malaysian government against an Abu Dhabi sovereign wealth fund. Now, the facts of that are pretty well reported and extremely juicy, but I'm going to steer clear of that in case I say any facts that are not reported. But the salient facts for the purpose of the anti-suit, there was an LCIA arbitration between the parties, which they settled. They settled it by way of a consent order and simultaneously 2 settlement deeds, which themselves had LCIA arbitration clauses in them. Those settlement deeds included an obligation on the parties not to take any steps to challenge the consent award, and it was an event of default if they did. Now, following a change of government in Malaysia, the Malaysians did wish to challenge the consent award. They said it had been procured by fraud, so they issued a claim in the commercial court under Section 68 of the Arbitration Act. The Abu Dhabi parties then immediately started an arbitration under the settlement deeds, and there was a fight between the parties in court as to which should go ahead. So Abu Dhabi saying the court proceedings should be stayed, Malaysian parties saying the arbitration should be injuncted. We lost at first instance, but we won on appeal. Now, on the face of it, it might seem slightly odd.
Who are we? Sorry.
The Malaysian parties.
Right, yeah.
Malaysian parties. It might seem slightly odd, and this is one of the things that the Abu Dhabi parties were saying, that, all they were doing was starting an arbitration using the contractually agreed dispute resolution procedure. But the Court of Appeal said, no, that's too simplistic analysis. When they agreed to the first arbitration, they were agreeing to arbitration in London, and when you agree to that, you agree to the supervisory jurisdiction of the court, which includes, as a mandatory provision under the Arbitration Act, the right to challenge any awards on the grounds that they're procured by fraud. And so you've already agreed to that jurisdiction, which you can't contract out of. And so it held that the second arbitration was both an infringement of a legal right and was vexatious and oppressive, and so granted the injunction to restrain it. Now, the second topic is injunctions to protect English arbitrations by restraining foreign proceedings. And there was a recent case on this about 3 weeks ago from the Court of Appeal called Anti-Suit and Chubb. That was a case concerning a construction agreement, a Turkish claimant, construction company, and a Russian defendant, Chubb. Now, it was all about a power plant, the construction of a power plant in Russia. And the construction agreement included an ICC arbitration clause with arbitration in London. Chubb started a claim in Moscow, and Insarts applied for an anti-suit injunction, saying that this all should be subject to ICC arbitration. The issue, or one of the issues in dispute in the Court of Appeal, was that Chubb said, you, the English court, shouldn't even get involved in this. This arbitration agreement is governed by Russian law, and you just have to let the Russian court decide whether the dispute does or does not fall within the scope of the clause. Mr. Justice Andrew Baker agreed with that first instance, but the Court of Appeal said that that was wrong. This similar analysis to Minister of Finance. When you agree to the London arbitration, London as the seat, you're agreeing to the English court being able to decide issues like that, issues ultimately about the substantive jurisdiction of the tribunal, and it's part of Lord Justice Popplewell used the phrase curial jurisdiction. It's part of that jurisdiction to grant anti-suit injunctions to protect the London arbitration.
So it was London arbitration, but the arbitration was subject to Russian law.
Well, So the
arbitration agreement was English law.
The arbitration agreement, they said, was English law. That's the point of dispute between the parties. The Court of Appeal found that it was English law.
Right.
Can I just say, this is the quality of the viewers that we've got following this programme. So before you mentioned that case, Joe, we had a message from Kevin Cooper as a partner at MFB. Joe's answer to Paul's question about whether proceedings must have been commenced was reinforced by the Court of Appeal in the recent Enker and Chubb. First instance judge criticised Enker for not having commenced arbitration before seeking ASI. Court of Appeal disagreed. But he does add this, P.S. what's happened to Claudia's cat?
He was meowing earlier, and luckily I don't think anyone heard, so I kind of shoot him.
Get the cat back. Is it me now?
Paul, it's all over to you.
I'm going to just have it's the same sort of experience as Joe had. First instance, though, case that Joe and I did, in fact, where we came second. We're not like Poonam, win all our cases. And that was a case where we'd had a bit of a long run on this one. So basic situation is AmTrust, obviously well-known American insurer, has a relationship with Italian brokers, Trust Risk Group, and it's governed by a terms of business agreement that the parties agreed in 2010. The next year, January in 2011, they agreed a second contract called a framework agreement, which sort of covered some of the ground that the terms of business agreement did, but not exactly. And the terms of business agreement number 1 has English law and jurisdiction, agreement number 2, Italian law and arbitration. And the parties fall out in 2014. The Italian brokers take 32 million euros out of a trust account, and AmTrust sue for an injunction to get the money back. And the Miss Justice Blair finds at first instance, yes, you can have the injunction, and they argued that the second agreement had amended the first, but Miss Justice Blair disagreed. He said, no, the first agreement survives and it's English law and jurisdiction. Went to the Court of Appeal, and Court of Appeal agreed. And so therefore we had, at first instance, Court of Appeal, the view being taken that it was English law and jurisdiction. They then, in the arbitration in Italy that they commenced, sought to bring in the disputes that they were complaining about that were part and parcel of the English proceedings. And we went to try and get an anti-arbitration injunction from Miss Justice Andrew Smith, and he refused it on the bit like Miss Justice Baker in Enker and Traub. He refused it on the ground that really that's a matter for the Italian arbitrators. We got permission to appeal, but then regrettably the parties settled their differences. So there you go. What's next, Poonam?
Well, it's me talking about when I win cases as opposed to you talking about when you lose cases, Paul.
I just say I'm impressed that we've done this many podcasts before we've come to the subject of which is interesting cases that I was in.
Well, at least I told you about one we lost.
So you get an anti-suit injunction, and hopefully the person obeys it and stops their proceedings abroad. But I seem to always be against particularly nasty people. And I've had many cases where they've then ignored the anti-suit injunction. So what do you do about it? And two practical things. First of all, don't underestimate the importance and power of taking contempt and committal proceedings. I mean, obviously, many of our clients are in foreign jurisdictions, but you can still get an order for contempt and committal against the director of a foreign company. And obviously, they're not going to be arrested unless they come into the jurisdiction. But you'd be amazed how many cases then settle because these directors do want to come to England without fear of the cuffs. But piece of warning, guys, it's CPR 81, I think, that deals with contempt proceedings. And that CPR does not comply with the simple, understandable idea. It's Delphic, impossible to follow, loads of pitfalls. In fact, I think Joe kindly told me it's being reviewed. They just finished a review of it, right, Joe? And it's going to be redrafted. But if you get something tiny wrong, your whole contempt thing could go wrong. So really concentrate right from the outset and get someone who's done contempt proceedings before. The other rather useful tool, which I'm quite proud of because I did it, is so I got a case, I got contempt, they ignored it. I got a Morava, they ignored it. I had my anti-suit already. And they started getting judgment after judgment against my clients in China in breach of the anti-suit. And I went for a full trial on the merits here, seeking damages. And it's really, really easy. You can seek as damage the costs you waste abroad. But the authorities in the books have been suggesting that if you want to seek the money equivalent to the judgment abroad that's been obtained in breach of the ASI, you'd need to show that if they'd sued you here, you wouldn't be liable for damages. And I said, nah, forget that. I have a right not to be sued there. I get as my damages everything that they get over there, and you can give me a judgment. Now, we don't need to look at what would happen if they've sued me here because they've chosen not to sue me here. And I won that at first instance. That point didn't go up to the Court of Appeal.
Hang on. I've got a question.
Yeah.
If you've got no assets in the jurisdiction where they're trying to enforce these judgments they should never have obtained, where's your loss?
We've got liability still, though.
No, right? They can't recover the assets. So if they can't recover the assets, you've suffered no loss, surely.
Yeah, did you get an indemnity, like to be indemnified against anything you pay under the foreign judgment?
Have you both finished asking me questions so I can answer now? I have a complete cause of action. I gave an undertaking that I wouldn't seek to execute my judgments if I hadn't already paid them. But what I said I would do with my judgments is use them to set them off against any measures the naughty people took against me. I was acting for a big ship owner with lots of fleets of ships, so they were going to arrest my ships to enforce their judgments. And I wanted my judgments here, which were mirror judgments of the same amount, to be able to set off against any attempt to arrest. But I did, if I recall, give an undertaking not to enforce in my own way till I actually had to pay.
Can I just... we're getting messages, we need to move on. Should we do the sort of feedback on your exclusive jurisdiction clause?
Right, so the question was, can we quickly have the first slide up, because you three are going to have to answer. Is this an exclusive jurisdiction clause? Who will I go to first? Claudia, is it an exclusive jurisdiction clause?
No.
Joe?
It feels like a trap, but no.
Paul?
No.
Okay, and I've got the results of the vote, and 71% of our viewers agreed with the three of you.
Because I think shall is necessary but not sufficient, right?
Yeah.
That's my idea.
You're all wrong. That's effectively the jurisdiction clause. You just are. That's the jurisdiction clause I had in the case I was talking about. That point actually went up to the Court of Appeal. Very briefly, they accepted that the first sentence on its own, and I think you all agree, is an exclusive jurisdiction. The second one, if notwithstanding the foregoing, was the problematic one, and I assume that's where you all are. But the Court of Appeal was persuaded that actually you don't need to say notwithstanding the foregoing unless the first sentence gave you an exclusive jurisdiction clause, and accepted that the second was, well, if notwithstanding exclusive, you sue me in a country that ignores exclusive jurisdiction clauses, that is what I want.
Poonam, we warned you that this was obviously a bad day at the office for the Court of Appeal. I don't know what you did. You looked into their eyes. I don't know what went on there, but it plainly is not an exclusive jurisdiction clause.
Well, take that. Guys, you just saw losers. Okay, I'll be honest, I was quite nervous when we went to the Court of Appeal.
I bet you were.
Okay, there we go. What can I say? Right, I know we're running out of time, but let's do point 2. If I could have the slide up very quickly. Imagine that I'm sued abroad when I have this clause, it's exclusive. The 6-month clause, time limit. The other side starts proceedings abroad in Brazil within the 3 months. Sharpco defend those proceedings, saying, no, there's an English jurisdiction clause, and they take, no, I've got this wrong. Razor say it's an English jurisdiction clause, and they make arguments in Brazil. They then, after the end of the 6 months, start proceedings here for an anti-suit injunction. Sharpco say it's not exclusive, we dealt with that. They also say, no, don't grant the anti-suit because we thought we were going to argue this in Brazil, and now we'd be time-barred here. So, guys, question for all of you. Would you grant the anti-suit, or would you take sympathy and say, because it was time-barred now, I'm not going to grant the anti-suit? Let's go with you first, Paul.
I'd grant the anti-suit, unless there's some sort of estoppel or some other reason whereby they could say they were misled or tricked or something. I can't see any basis upon which sort of sympathy is a good reason to refuse it.
Okay, Claudia?
Yeah, I was going to say, I grant the anti-suit. It's important that the arbitration, Brazil hadn't heard the thing, so there wasn't this Comity issue. But also, if there is this trickery that Paul's spoken about, Lady Justice Cockrell had a decision recently, Times and National Bank and Fujairah. There, they were basically playing silly buggers and hiding under the parapet until the time limit had expired. Then they popped up and anti-suited. She said you can have your anti-suit on terms that you don't rely on the time bar. So I'm not sure here it would go in, but if there is something, so basically they have delayed because they are trying to give themselves a time bar defense, she might say, actually, you can't do that. She being the judge here, the judge might, you can make it conditional, basically. And
okay.
But the remedy is always in their own hands, isn't it? I mean, sorry, Joe.
What remedy is always in their hand, Paul?
Well, they could sue in the right jurisdiction, couldn't they?
Yeah, correct. Okay, Joe, are you on the same mind, or are you going to be?
I agree.
You would grant it as well.
Yeah.
Okay. I agree. That was a boring question. The first one was much better. Okay. For the first time ever, there is unanimity on Quadcast. What's happening to us, Paul?
There is on that specific question, but when Paul says the answer is always in their own hands, it's not always. I think there can be facts that mean that you don't know who you're supposed to sue, or you don't know where you're supposed to sue them. And if that's because you just haven't bothered to find out, or you haven't tried hard enough, I agree with you, Paul. But sometimes it's because the defendant has been sneaky. And there, I think the court can tailor the remedy to stop you being sneaky, basically. And that...
It would need quite a hard thing, Claudia. You've got your contract. You can see there's a time limit. Take your protective things. If you're not suing in the right jurisdiction on time, it's almost because you're trying to say, "Oh no, I'm time barred."
It would have to be clean hands, wouldn't it? You'd have to have something where you
in that horrible case, they sued in the right jurisdiction, but they sued the wrong person, and the person who they sued, they read the case. It's quite interesting, but. There may be cases where the defendant has acted in a way to lead you to believe that you're doing the right thing, and then says, "Oh, actually, you're not."
But that's an inherent risk in any commercial relationship of that sort, and nothing to do with the whole anti-suit issue. You run that risk in any situation, surely.
So what's interesting is we managed to keep consensus for about 10 seconds, and now we're back butting heads. Paul, are you going to tell our viewers what's coming up next on Quadcast?
Right, okay, so a few things to say, reaching the end of this show. Firstly, do subscribe. If you like these Quadcasts, the webinars that Quadrant Chambers put out, please subscribe on YouTube. If you subscribe, you'll get notification whenever we put out video, not just Quadcast, but any video, any webinar that Quadrant Chambers puts out. So I encourage you to subscribe on YouTube. I also want to say thanks to our producer, Emily Saunderson, who sends us messages throughout the show telling us what we need to do, and to Ben Jacobs, Fish Eyes Production, who's done the vision mixing and streaming service. Next time...
and thank the voters who agree with us and not with Puna. All right.
And thank the voters, and thank everybody that voted, actually. Yes, so it's better when you get involved and vote. It's a lot more fun. Next time on Quadcast, we're going to look at good faith clauses, the implication of good faith obligation, the relational contract idea that we can see coming through from, as he was at the time as Justice Leggett, now Supreme Court Judge Leggett. We're going to look at that, but it won't be next Thursday. We're going to take a week off, so it will be in 2 weeks' time. That's Thursday, 4th of June at 5 p.m. You'll get an invitation in due course, but until then, it leaves it just to me to say happy birthday, Poonam, again, and to everybody else, goodbye.